All right. Good afternoon and welcome to today's afternoon session of the Court of Appeals oral arguments. Uh, During this unprecedented time, we are doing all of our arguments remotely via Zoom, but the court continues to handle a full docket. So it's a brave new world. I know this makes it challenging for everyone, including attorneys, and so I want to thank counsel for your time that you've spent preparing for this case, but also for this argument and your flexibility in doing so. And now I'd like to take a few minutes and introduce the members of our panel who probably need no introduction. But first we have Judge Melissa Taylor Standridge, who joined the court in 2008, and she joins us from Leawood today. And then Judge Catherine Gardner, who joined the court in 2014 and joins us from Topeka. And I'm the presiding judge for today. My name is Sarah Warner. I'm the newest member of the court, having just joined last year. And I'm here from Lenexa. And it's exciting today to have an all-women panel for a number of reasons, but not the least of which is that next week we'll be celebrating the 100th anniversary of the 19th Amendment, which granted women full and universal suffrage. So it's fitting today that we have a panel of women judges. So at this point, I'd like to call the one case on this afternoon's docket. That's case number 121447, Catherine Roll, a disabled person by and through her co-guardians, Teresa Roll Kerwick and Mary Ann Burns, versus the Secretary of the Department of Health and Environment et al. Would the parties please state their appearances?
David Calvert for the plaintiff.
Your Honor, Arthur Chalmers of the Attorney General's Office for Secretary Howard and Superintendent Dixon.
And Mr. Kerwick, I believe that you are muted.
Used to be a universal.
How is it? Is it coming across now?
Yes, it is. Yes, it is.
I may just have spoken too inaudibly.
All right. Well, we have 20 minutes of argument today. Mr. Calvert, how much time would you like for rebuttal?
Like to reserve 7 minutes for rebuttal, which Mr. Kerwick will do.
All right, 7 minutes are granted, and you may begin.
May it please the court, my name is David Calvert. This is a civil rights case brought by the co-guardians of Catherine Roll, who is a 65-year-old intellectually disabled lady who has called Parsons State Hospital home for over 50 years. She is safe and happy there, and she receives all the services that she requires. The medical records that are in evidence establish that she measures less than 1% in ability and of the population as a whole, and functions verbally like a 3-year-old, where other functions are only slightly higher. And those test results are detailed in our opening brief. Her civil rights are guaranteed by the Americans with Disabilities Act, the Social Security Act, and the United States Supreme Court. The state wants to discharge her to the care of an undetermined community agency for community-based treatment. Since Catherine is incapable of objecting to that discharge, her two co-guardians, her sisters, and the guardian ad litem selected by the state have objected on her behalf. The law provides that these objections are binding on the state. The United States Supreme Court spoke in 1999 in the seminal case of Olmsted versus LC by Zimring, in which they held that people who were disabled had a right to community-based treatment for persons with mental disabilities when the state's professionals determined that was appropriate. And second, and most important in this case, the affected persons do not oppose such treatment, and the placement can be reasonably accommodated. The Americans with Disabilities Act of 1990 provides guidance in terms of Part 2 of that holding that the affected persons do not oppose the treatment.
Counsel,
Yes.
before we get to part 2, I want to talk a little bit about Olmsted itself.
Yes.
And what was the context in which that claim was brought in Olmsted?
The context of that case was that there were people in an institution that wanted to be discharged to community-based treatment. And
So the people, the plaintiffs in Olmsted were seeking a more integrated environment than the state in that case was willing to provide.
yes,
And so it was within that context, the question was, under which circumstances is a state required to provide community-based treatment instead of institutional treatment, right?
that's correct. That's correct.
So does it necessarily follow from Olmsted that the converse of the Olmsted test also is true? That is, that there is also a right of an individual to be placed in institutional treatment?
To remain in institutional treatment, they have a right to do that if they qualify for institutional treatment. But that's their choice. The ADA simply provides that nothing in this part, referring to the ADA regulations, shall be construed to require an individual with a disability to accept an accommodation which the individual chooses not to accept. So in this case, as you'll see, the individual, through her guardians, has chosen not to accept transfer to community-based treatment. And the trial court, in essence, completely ignored this provision or simply gave it short shrift and never directly addressed it. It is controlling. It is unambiguous. Nothing in this part means exactly what it says.
Mr. Calvert, let me ask a question. If we would find in your favor, under a different set of circumstances, let's say that someone is placed in an institution that is functions at, or really we could take the people that they're talking about that are coming into this institution that have behavioral issues, kind of how this is morphed into kind of a different institution. Is it your position that once you're in that institution, that you have a right to always refuse community-based care once you're in there under Olmsted?
Yes.
No matter what the circumstances are?
Well, I'm trying to think of some circumstances, and I can't really think of any. Of course, the patient has to be qualified to be there.
Right. But once they because the qualifications are kind of different to me, based on my review of the record, and please correct me if I'm wrong. The qualifications are different than really the standards that they're using now. I mean, those are different, the qualifications and whether or not it's the most restricted or the least restricted. Okay, those seem to be completely different than what the qualifications are.
Well, most restrictive and least restrictive really isn't relevant in this case. Although the trial court made a finding that there was a federal regulation regarding least restrictive, there is no such regulation. It
Well,
doesn't.
I thought under the guardianship law that you brought, the law about guardians, that the guardians have a duty, a fiduciary duty to put them in the, maybe I read that wrong.
Well, their first fiduciary duty is to protect the civil rights of their client, of their ward.
Oh, right. Yeah, 593075B4 requires a guardian to assure that the ward resides in the least restrictive setting appropriate to the needs of the ward, right?
That's right, if that's appropriate. And in this case, it's not appropriate. I mean, the needs of the ward are such here that, first of all, she does have an IQ less than 70, which is.
So speaking to that, the question I had when I went through all of this is, are we dealing with a factual question or a legal question? Because Parsons sure put on a lot of evidence. Dr. Rhea, Nathan Gromit, Corey Medlem, Dr. Menon, Nancy Holden, Tammy Monuse, and each of these individuals were personally familiar for years and years and years and worked with Ms. Roll in various capacities. And it seems like the judge made a factual decision that this was the most restrictive environment and that community-based would be least restricted. Is that a factual question we can review?
I don't think so, but I'm not sure that that's even true. This may be that she needs the most restrictive environment. And the least restrictive environment puts her out in the community where, she'll walk across the street without looking for traffic. And she's done that for a long time.
Well, I guess I meant least restricted environment in which, I'm going to use that whole thing, in the least restrict environment appropriate to the needs of the ward. So,
Yes.
yeah, it seems like, do you believe that the district court made a factual finding with regard to that? Because I can't pinpoint exactly where it was, but I read the decision and I felt like the district court made that decision.
Well, I'm not sure that the court made that decision. She just quoted a bunch of people and listed a bunch of people without any references to what their statements were.
Okay. And then also, in your brief, the issue's kind of framed, does the ADA prohibit Parsons from discharging role to community placement over her objection? And then in your brief, you say the issue is not whether providing community-based treatment violates the ADA, but whether Parsons respects Roll's freedom of choice under the second Olmsted prong. So I'm having a little bit of trouble getting a handle on what the issue presented is.
Well,
Can you help me?
I think that the issue really is,
Yeah.
does she qualify for treatment at Parsons, and does she object? And that's the issue under the ADA, it's the issue under Olmsted, and it's the issue under the Social Security Act.
Okay, so the ADA doesn't say anything about objection. Now, CFR 35.130E1 talks about, you already quoted that, nothing in this act shall be construed to accept an accommodation. And that brings me to whether it makes a difference whether or not we're talking about whether Ms. Roll is in the community and could decline accommodation, or whether the fact that she's now, even if she was only in there for a day or in there for 51 years, whether she can decline an accommodation. Is there a difference? Do you see a difference?
I don't see a difference whether they call it a transfer, discharge, or accommodation. she's,
Oh, I meant more if she was living in her sister's home, okay, and you know, and they wanted to put her in. Well, that's not a good example. If she was in, all right, I'm using up your time. Please go ahead.
well, I wanted to also get to the Social Security Act, which contains the freedom of choice provision, and it's best stated in the regulations, which are that when you have a waiver under, and as we do in Kansas, and she is at Parsons under the waiver, the state has to provide that she will be informed of any feasible alternatives available under the waiver. And those alternatives, in this case, are Parsons or community-based treatment. And second, and most important, she has to be given the choice of either institutional or home and community-based services. Now, that's pretty clear that she has a right under that statute to have a choice between Parsons or community-based services. And
Mr. Calvert, counsel, was that presented to the district court? And in
Yeah.
what context was it presented?
it was tried and it was presented. There was a motion to amend the pleadings after trial, and that motion was granted to add the Social Security Act because the court found that that issue was tried. So,
And under the Social Security Act, what is the governing standard? Is it that a person has the right to freedom of choice of placement wherever they would like to be, or are there limitations on that freedom of choice?
I don't think there are any limitations on that. It's pretty clear. If it's decided that they have a need to require the level of care that is provided at Parsons, she has a right to choose between Parsons and community-based care.
But doesn't that, what you just said, require first a finding that she has a level of need that meshes with the care that Parsons provides?
Right, and that level of need is determined by the fact that she has an IQ of under 70 and that she needs active treatment. And she is clearly in active treatment by the testimony of any number of the witnesses that I may or may not get to. So she does have the need for that. She's likely to require that level of care, as the statute says, because of those two factors.
Counsel, we're coming to the end of your argument time, but I know we've been asking you a lot of questions, so I'm going to give you 2 minutes to wrap up with whatever you'd like to say.
Well, the court clearly abused its discretion. And that occurs, as this court knows, when judicial action is either arbitrary, fanciful, or unreasonable, where it's based on an error of law or an error of fact. And the errors of fact in this case are really in two different categories. There are findings that are inconsistent with the evidence, where the court made one finding and the testimony is contrary to that. And, for example, making part of the determination on a finding that Catherine decided that she wanted to go into community-based care, and that which is absolute hearsay. And I didn't think of that at trial. But the fact of the matter is that the witness that testified to that said that she based that in part on a conversation with Nathan Gromit, who went with her to the tours of the different agencies. And then Nathan Gromit said, I just don't think she kind of understood what was going on. And that's true. She's simply incompetent to testify as a witness. And everybody agreed she couldn't testify. She couldn't even be sworn. Other material evidence was simply ignored and not mentioned by the court, the most notable of which is the testimony of the guardian ad litem. And he wasn't even mentioned in those findings. The guardian ad litem was asked for by the state. He was selected by the state. He's a Parsons lawyer with a degree in psychology and experience dealing with patients at Parsons, and any number of other facts in the medical records that the court simply blew off, for lack of a better term. This court.
If you wrap up your argument a little bit, we're coming to where I've given you some leeway, but we're at the end of our time. All right.
I'll go to the last page. All right. And the law regarding injunctions has a four-pronged test. And the first is that she suffered an irreparable injury. And in this case, and in ADA cases, that's an injury to her rights. Remedies of law are inadequate. There's no hardship to the state, and the public interest would not be disserved by a permanent injunction. So we urge the court to find that fees should be awarded and that a permanent injunction should issue. Thank you for the additional time.
Thank you. Mr. Chalmers, I'll give you a few more minutes, so you have 23 minutes.
Thank you, Your Honor. May it please the court. In this case, the plaintiff decided to go to district court to bring a civil rights claim, as opposed to seeking some sort of administrative relief based on the decision by a treatment team that it was in the best interest of Ms. Roll go, and frankly, one that was consistent with federal law, to go to the least, or the most rather, integrated center. The case was tried after a motion for summary judgment failed that had been filed by the plaintiff. And it was tried on the idea that whether it was in the best interest for her to be moved to community placement, and whether, and this was the issue that the plaintiff had presented, whether the guardian's opposition to community placement was reasonable. So they put that on the deck, and they lost. They lost factually, but by the time the case was presented, and reading the record, it's obvious that what the judge decided was, and understanding now what the case was about, that they really hadn't stated the claim. In fact, the judge found in her opinion, I think it was at page 50 or 48 of her opinion, that they failed to state a claim as a matter of law under the ADA. And that was really conclusive for the case. Now, the case, however, was presented under the ADA under an Olmstead theory. You talked about that a little bit. Olmstead held that it's unnecessary, that unnecessary segregation to individuals with mental illnesses in more restrictive settings is discrimination per se. If you keep them in a setting that is not the least integrated, you made out a prima facie case of violation of the ADA. But there are defenses, and one of the defenses is the concept that the ward or the patient does not want to be moved. That was the defense raised in Olmstead. Now, the mandate, the basis for discrimination was that you have to integrate when you can. And the rationale for that was twofold. In the plurality decision by Justice Ginsburg, Justice Stevens concurred and gave the fifth vote. The rationale was that keeping people in the least integrated setting was an unwarranted assumption that was based on an unwarranted assumption that the person in isolation is incapable or worse, unworthy of participating in everyday community life. And second, the rationale was confinement in an institution severely diminishes everyday life activities. Now, the point being,
Counsel, I want to ask you something that has been on my mind as I've been reviewing this case. And that is in Olmsted and in virtually every other case that I've looked at that discusses the Olmsted standard, there has been a proposed transfer by the state to a specific community-based setting. And we don't have that here.
never got that far.
So that's something where Ms. Roll would go from here is still something that needs to be determined.
The ideal world is that decision is made in with the team, the treatment team, with the guardian, with the agencies who have responsibilities, and there are several among the state, to find an appropriate placement. We never got that far. The guardians objected. The guardians, I'm not being disparaging, but they didn't want it to happen and wouldn't allow it to happen, and a lawsuit's filed seeking an injunction. Temporary injunction was put in place, and that's where we are. So we didn't get that far. Now,
So right now, this is kind of threshold question. Can we even look at community-based treatment programs at all, or are we precluded from doing that because of federal law?
and I think that's where the district court went. After the trial, and there are findings of facts, and I'll talk about that, but after the trial, and it became apparent what plaintiffs were, I think what the district court was saying, you don't state a claim for disability discrimination under the ADA, that you don't fit the rationale. There is no reverse thing going on. There's an exhibit, it's found in record volume 12, it's defendant's exhibit 23, that does a pretty good job of distinguishing what a community agency is and what a hospital placement is. It kind of gives you all those different elements. The point being that what Olmsted was struggling with is how do you have discrimination against somebody with a disability if you're treating them all the same, keeping them in the same high level institution of confinement. And the court said, well, that by itself is discrimination. That rationale doesn't fit here. And that's why all the courses that have looked at the obverse, they call it that Olmsted theory, it says it does not state a cause of action. And that should be, I think, the end of the story. This is not a case where there is discrimination by community placement, as you point out. We never got that far. But even if you wanted to put them in community placement, there may be some remedy for that. I think it's an administrative, but it is not under the ADA. And that's should be the end of the story as far as affirming the judge on the basis of the ADA claim. Now, as it related to substantial
Mr. Chalmers, let me ask you a question. I understand what you're saying. There's the ADA, and then you have this whole, you have Olmsted, which, is kind of the opposite, as Judge Warner noted earlier, with Appellants Counsel that has the three-part test, etc., which is kind of the opposite. But you do have these regulations, which of course have the force of law. And Appellants Counsel brought up the specific regulation, 28 CFR 35.130E1, which says nothing in this part shall be construed to require an individual with a disability to accept an accommodation under the ADA, which such individual chooses not to accept. And in fact, Olmsted did cite, and this is separate and apart from the three-part test, did cite to that regulation. And it seems as if this case was brought as a civil rights action under the ADA, and it's saying, look, you're violating my civil rights because you're violating, you're making me accept an accommodation that I don't want, which is directly contrary. Can you respond to that?
Sure. Let me make 2 points. First, the regulation, the 35.130E, is a description of the defense. It does not describe part of the prima facie case. I know it's been talked about in some of the cases as a three-part Olmstead test, but what the court was saying is you've got discrimination. And I think Justice Stevens' concurrence does a pretty good job laying that out.
Well, I'm
And
just
then they
talking
say-
about this regulation with, let's just talk about it without the context of Olmstead.
Sure. So what you have is a regulation that's written by the Attorney General, U.S. Attorney General's office, that is describing the defense that is available to a discrimination claim. It's not providing an affirmative basis for an ADA claim. The elements for the ADA claim are described in the In Re Estate of Broderick case by the Kansas Supreme Court in 3 parts. You've got to have the disability qualification. You have to have you've been excluded, even though you're qualified, and it has to be because of your disability.
Wait, I'm sorry. What did you say? I'm having a little trouble
You
hearing.
have to be excluded because of your disability. Is the 3rd element for violation of the ADA. And so,
Well, isn't she saying she's been being excluded from consideration at
no, it wouldn't have been because of her disability. And honestly, she's not saying that. The testimony, the finding was that she agreed, and that's found in Finding of Facts 98 through 101.
Okay, so let's talk about that for a minute. Don't you think that's contrary? I mean, that factual finding, is that supported by substantial competent evidence?
Well, the finding there was based on a conversation that that Ms. Roll had with Ms. Vander.
Right, but Ms. Roll is incompetent. I mean, she's
Yes.
been deemed incompetent and has been appointed a guardian because she is incompetent. So why would what she says have anything? I mean, and the district court relied on that heavily in its opinion. The fact that I mean, I can quote you, the problem with this argument is that the request to keep Ms. Roll institutionalized reflects only the desires of the guardians. This position does not reflect Ms. Roll's desire.
Yeah, and I hear what you're saying, Your Honor. I don't know that there was ever a finding that she would be incompetent to provide testimony. That's kind of a
Well, isn't
slight-
that something that we can take notice of, given
I mean, a child can testify under the proper circumstances. I don't know that the court can make that decision, but I would raise a point on that because I think I find this point something I would like the court to think about a little bit. And that is,
okay.
there's a recent decision, a recent May 2020 article. It's at 40 Journal of Legal Medicine. It's written by a law professor out of Michigan, and it's saying taking choice seriously in Olmstead jurisprudence. And it's at 40J Legal Med 5, May 2020.
Was this in your brief though?
No, it was not. I'm afraid not.
I
It
think
would have been after my brief was filed, and I probably should have supplemented. I did not.
40J.
Journal Legal Medical 5, May of 2020. The reason I mention this is that it raises the debate that is going forward in the legal community and people that are dealing with the Olmstead jurisprudence on who makes the decision on selection. Is that the guardian? Is it the guardian with the court's approval? Is it, and they argue here, that in ordinary circumstances, it needs to be the ward. We need to think, as Olmstead thought, about these people and understanding that, yeah, they are.
Has the intellectual ability of a 5-year-old.
I understand. And I
Her
understand
IQ is
too.
50.
I understand also that there is a sentiment in both the psychiatric, psychological community, as well as the United States Supreme Court, and as well as our Kansas statute, that we want these people have the opportunity to be involved in communities with people that don't suffer from those disabilities.
Okay, I want to go
so
real
there needs
quick
to be some recognition as to their views on it. I'm sorry.
Okay, but she didn't testify, right?
No, she did not testify.
Okay.
She was available, but
Would you agree that the court relied on that finding as part of its decision?
I think that the court relied on it because it made that finding. I do not think that that is the predicate to its decision that they failed to state a claim as a matter of law under the ADA. I don't
Okay.
think that, yes.
And I did want to get your opinion real fast about what appellant's counsel said about that freedom of choice. I'm going to pull it up. I'm sure you're familiar with it, right? Actually, the
Is this the
district
Medicare
court,
free choice, Your Honor?
right, under the waiver.
Okay.
Right, under the waiver. I'm pulling it up. Oh, whoops, I'm in the wrong thing here. Attachment 1, I'm looking at the district court's journal entry. Let me see, it's way down at the bottom. But just why don't you give me, the district court cites a lot. I don't even know whether the district court was he or she, but under the HCBS waiver program, 42 USC 1396 C2C provides a waiver won't be granted unless they're, informed of their feasible alternatives, and at the choice of such, the individuals have a choice. And then we've got this choice of alternatives, and I'm not sure, this is on page 60 of the district court's opinion. Choice of alternative, the state assures that when an individual is determined to be likely to require the level of care specified for this waiver, they have to be informed and they have to be given the choice. So I'm just curious to hear what you have to say about that.
Well, the waiver repeats the administrative order or administrative regulation, which is 42 CFR 441.302D, which I think you're talking about. And but I think that the threshold question is, what was the district court saying as it concerned the claim that's before this court now? And I think the answer is the district court didn't decide that point.
I think you're right.
She did not reach that issue. And so I don't think it's properly before you now, but I am interested, and I'd like to talk about that first.
Well, let's talk about the impact of that the court didn't reach that.
Well, the impact of the court.
Should we remand it back down?
Well,
I mean, it was pled.
According to your, well, it was pled in a motion to amend after trial, but according to this court's authority, they would say that what Mr. Calvert was required to have done is bring it to the district court's attention that, look, we've got another argument here. Apparently you didn't understand what it is, and you need to rule on it in order to have the appellate court rule on it.
Well, the district court devoted 15 pages to this argument in its order.
Yeah, she obviously did not understand what the argument was.
Right.
I don't believe she understood what the argument was.
I think you're right. Okay.
But I don't think it's probably before the court. But you asked a question about the regulation, and there's a point on that. You need to distinguish between the regulation and between the statutes. And by the way, the statute, which is part of the ACA, the Affordable Care Act now, is now 1396ND2C. I'm going to say D2C. That's a different section than we were talking about.
N as in Nancy, D as in dog, and then what?
2 as in the
number 2. Okay, got it.
As in the capital cap. And the reason that's different is because Ms. Rowe is now 65, and so
right, so it's Medicare.
So it's still Medicaid, but it's a slightly different statute, and it's the one that would require that individuals who are receiving those benefits are informed of feasible alternatives to provision for skilled nursing facility or intermediate care facility services, which such individuals may choose if available under the waiver. Now, the way that's been construed, actually C2C, by the Seventh Circuit and by a district court New Mexico decision, is that you have to tell them about the alternative. The regulation takes it a step further and says, now you have to tell them about the feasible alternative and give them a choice. Now, and that language, as you point out, finds its way into the Kansas waiver. And the reason it finds its way into the Kansas waiver is if you don't have that promise, then Kansas is not assured to get its federal money.
Right.
It doesn't have anything to do with the individual. It has to whether or not we get
Right.
reimbursed.
I get it.
So now we've got that. The question you have is that a cause of action under 1983? And there are two steps there. One is you have to have a private cause of action under the statute. The courts are split on that. Some say, yeah, under the freedom of choice right or statute, there's a private cause of action. Some say no. The Ball case, which the plaintiff's side is probably the leader of saying, yes, there is that cause of action. Then you've got a second step is that you have to have a private cause of action under the regulation here. Because everyone agrees, I think, and it's not the United States Supreme Court case in Anderson that's cited in the brief makes it clear, a regulation does not give a private cause of action under 1983. Let me state that again. You cannot recover under the Civil Rights Act for violation of a federal regulation when the regulation goes beyond what the statute provides. I don't remember which justice it was. They talked about you can, well.
What case is that?
The Anderson case is the one that
Says you can't, no
versus
private cause of
Sandoval.
action under 1983 for
Yeah,
regulation.
Alexander versus Sandoval, 532 U.S. 275. They refer to the sorcerer or apprentice can't do what the sorcerer can do. So
Okay.
the point is that the question you've got is, do you even have a private cause of action? And then you got an issue, which I hope you never reach, which is whether it's constitutional. But I think the way to answer it for your purposes for this appeal is that they didn't present evidence that would be needed to establish a cause of action, even if one existed. And that goes back to the point that we never got so far with this choice.
There was never what? I'm having
we never got this far to make the decision on what choice options to make.
Counsel, I want to stop you there just so I understand that. So you were saying that going back to what you and I were discussing just a few minutes ago, because of where we are in this litigation, that is, we are at this threshold question, can we look at community-based treatment programs? We're not at a question where there have been a number of, say, different treatment programs presented, and then Ms. Roll and her guardians would have a choice as to which of those programs, or perhaps Parsons also, but which program she chooses. Is that right?
Yeah, I think that Doe versus Kidd, and I'm agreeing with you, but I think this helps articulate it, at least in my mind. They drew a distinction between whether you give an option to individuals the unfeathered right to choose the appropriate setting for their placement, or whether it's once you choose what is the appropriate setting, among that appropriate setting, they get the choice. And they say that's where the federal regulation comes into play. It is as between that setting. So here you've got Parsons and you've got other state entities under the plan that are referred to as institutions when we're talking about Medicare or Medicaid rather. And these may be privately owned, but they're licensed and they provide the ICF, IID care level in a less restrictive manner. You've got those that are under the plan, and then you've got community choice, which candidly, I think the people out in Parsons thought was the best solution for this role.
Mr. Thomas, let me ask you a question. I hate to interrupt you. The unfettered discretion about the range of setting versus once you're in the range selecting, you said something about Doe or Roe, and I need the cite to that case.
Yeah, it's Doe, DOE versus Kidd at 501 F 3rd 348. It's cited in the brief, Your Honor. I can't.
Okay, I got it now. Thanks. Okay, please continue.
But and this was lost on me. You all probably understand it, but there you've got a hospital setting, and in my mental image, I kind of thought of one flew over the cuckoo's nest. I hope it isn't like that, but you've got a very restrictive setting And that's the setting that's described in Defense Exhibit 23 that I talked about a little bit more. Then you've got, if there's a more appropriate setting, it can be within the plan or out of or within the waiver. The waiver is the community, but you have other entities around the state that provide this intermediate level care that would be appropriate. And it is that choice between those entities that would have to be offered and discussed with Ms. Roll and her guardians. And we never got that far. Now, what the district court found, furthermore, in my opinion, is that, look, if we're going to talk about who makes this decision, if it's not the ward that makes the decision, then we've got a Kansas statute that says the guardian's ability to conclude where to place this ward is limited. They can't put them in a more integrated environment. They have to look for or less integrated environment. They have to look for the more integrated environment. And that is always subject to court approval. And here you had a trial with a great number of witnesses, lots of exhibits, and with respect to Mr. Calvert, who articulates one part of the case, he articulated that case to the trial court and law. And the conclusion is it really was in the best interest of Ms. Roll to be in a more integrated environment and probably community service.
Well, the best interest is not the standard. Under 59.3075, it's to assure the ward resides in the least restrictive setting appropriate to the needs of the ward, which I didn't really see in the district court consideration, the fact that she'd lived there 50 years. And I think that appropriate to the needs of the ward, I think, given her intellectual disability, I don't know that the court considered.
I thought that was what the whole case was about. I think that was what the testimony was about, saying, look, we have to get around and set aside some of our preconceived notions. I know you don't have them, maybe I did, that people with this level of 3-year-old or 5-year-old can't be put into a community setting, can't have people that come in and check with them and help them and educate them and do all those things, that they can't do that they need to be pushed off into an institution. We have to get past that. And I think that's exactly what the district court found. And I think that finding is best summarized in finding 114, Your Honor. I think that's the one where maybe even if I look back at it, she may have used the language that this is the most appropriate setting. Because I think that was trying to track the language as it concerned the 59.30.75. I know that in other parts of her decision, she talks about 59.30.75 and reaches the conclusion that the guardians really should not have and can't try to argue for a placement at the higher institutional level. My point is that if someone has to make that decision, let's not default to the guardians making that decision by themselves. If we're going to look to state law, if that's the way it works under the statute, if we're not going to look at what the ward's interests are, or at least we're not going to give that controlling deference, then let's look to the controls that are already placed in our state, which says that the court ultimately will review what the guardian's decision is and its supervisory powers over the ward. And it did that, I think.
Counsel, I hate to interrupt you because I know you're on a roll, but you are at the end of your time. But I want to make sure that if there are any other questions from the panel, we get those.
I do have one question. You're saying 114, which is kind of the summary. I'm looking at that now. So the finding is basically there that Ms. Roll's guardians refused to cooperate in placing her in a less restrictive living environment. How can the court make such a finding when there is no less restrictive living environment presented to the court?
Well, there were less restrictive living environments presented to the court. There were, in fact, testimonies from 2 community development and disability organization representatives that talked about that. I was really focusing on the language in 214 saying, in spite of Ms. Roll's adaptive living skill, her lack of problematic behavioral issues, her expressed desire to live in the community.
Her expressed desire to live in the community, which we talked about.
Services available to meet those needs of Ms. Roll if transitioned to a more restrictive or less restrictive living environment. That was the part I was focusing on. clearly, as you go through the other findings, you'll find plenty that talk about what her
Right.
capacities were.
But
And
that did point out the fact that even in the conclusion, the district court relies on the fact that she said she wanted to do that.
I think that was a factor that she made in her fact
Yeah.
findings.
Yeah. Okay. Thank you very much, Mr. Chalmers.
Thank you, Robert.
Any other questions from members of the panel? All right. Mr. Chalmers, do you want to take 30 seconds and wrap up, or are you done? Yeah, looks like you're. Oh, you're muted right now. Oh.
I think that your administrative people figured I was done. Thank you, Robert.
All right. Thank you. Thank you, Mr. Kerwick. It's now your turn, and I'll give you 10 minutes. You are currently muted, however, Mr. Kerwick. Still, yeah, still. There we go. All
Am I
right.
going now?
Yes.
Uh, in that regard, and it's kind of irregular, I'd request the court, lest we talk over each other, if you just wave at me if I'm not coming through audibly. I'm not sure I've got this all calibrated optimally. May it please the court, I'm Steve Kerwick. The ward, Catherine Rawls, my sister-in-law, as is one of the guardians, Mrs. Burns, and the other is my spouse. Why are we here, and why are the guardians resisting, or why have they in the past resisted a placement outside of the Parsons State Hospital and Training Center? The one big thing, and I think Judge Standridge is onto this from what you're going, is there's a distinction here simply between an initial placement. The initial placement of Catherine Rawl into the Parsons State Hospital and Training Center was while I was in high school, almost 50 years ago. This is a matter of taking a 65-year-old woman now who's been in Parsons, the only place she's known to live, for 50 years, and uprooting her into a fresh and unfamiliar situation. I think that may not be very immediately legally controlling, but it is something that ought to color all of the evidence evaluation and everything else. Judge Maughan never talked about that whatsoever. And the reason I think that's kind of important in the context of this case is this is basically an injunction and a matter in equity. One of the earmarks of equity, or going back to Pomeroy's equity and all the development, is preservation of the status quo. And that's what we would like to have. The state is trying to interfere with the status quo pretty dramatically. I have two or three what you'll probably consider as rhetorical questions. I like to think of it and analyzing this as thought experiments on the pros and cons of each side of the case. And those are the issues that I think ought to be in the back of the panel's mind when you rule on this. The first one, what's the role of the Federal Americans with Disability Act here? Now, I can remember in 1990 when that went in, the publicity was very extensive, certainly at least in our profession. This was something that was a new, significant addition to the tapestry of our civil rights laws, giving rights and other things to people who are disabled, as opposed to action by government or whoever else. What role will that have in reviewing this here? What kind of purpose and policy is there behind the Americans with Disabilities Act? Is it, and I think this is what the state would have here, is it designed to grant vast discretion and almost unfettered regulation of the decisions by state bureaucrats as to budget, management of patients, personnel, and so forth? Or is it designed to protect the rights of the disabled and to make sure they're subject to more scrutiny and no arbitrariness and no decisions made for I'll want to say, for want of a better word, say harshly cynical kind of motives? That takes me to the second question. And I think it's very clear from reading the opinion, and we're on to it, that Judge Maughan had absolutely no regard for the opinions and decisions of the guardians in the case. She had nothing for the guardian ad litem either, since he's not even mentioned in, I don't know, what was it, 60 pages of journal entry. And he agreed with the proper guardians. Who should have more dignity assigned to their wishes and their desires with respect to this ward here? I think Judge Standridge has already figured out the situation that Catherine Rawl doesn't have and can't express a legitimate, succinct, sentient kind of opinion on what she would like to happen with her future. She was fed a shamefully self-serving couple of questions by the Parsons employee, to which she went along, yes. Nobody else ever talked about Catherine as being a person who can cogitate at a level to make a decision of this sort with all of the implications that are involved in it. But moving on, should it be the guardians or should it be the state employees? Well, where do the guardians get their authority or their role for it? Well, they're appointed by the probate court of Labette County. And as a result, they have a responsibility. We have to account to the court once every year in February for what's going on. They're subject to review by the probate court, who I think, if the state really had legitimate gripes about what Mary Ann Burns and Teresa Kerwick have done, they could try and intervene or try and make an appearance in the Labette County court, in probate court, and complain about what's going on. We're not here for approval overall. We're here to prevent the movement of the ward. On the other hand, and I omitted the biggest part, a guardian is a fiduciary. Just like a guardian ad litem, and in this case, our guardian ad litem was appointed at the demand of the state early in the case and was an individual selected by the state until they saw what his opinion is and didn't love him anymore. And then they tried to pretend he wasn't there, and Judge Maughan went along with it. In this case, we've got fiduciary duties as guardians. The guardian ad litem has a duty as an officer of the court, a bit appointed in this, to give true and honest testimony and give a good independent evaluation. And his opinions were an awful lot closer to what the two proper guardians had to say than they were to what all the Parsons state employees had to say. Let's think about Parsons, and I don't want to get ad hominem in this, but some of it's a little necessary. What are these folks' motivations? Keep in mind when this was. This was a time when budgets were a big issue in Kansas, and whereas there's talk about what the fiscal impacts were and what wasn't. This is a matter where the Parsons folks are trying to shake off one bit of responsibility, one patient they have. The folks who testified either are officers or former parties, or they're beholden to them in terms of their performance evaluations, their advancement, the preservation of their job and their job status towards there. They are not fiduciaries. If they have any duty to Catherine Rawl at all, it's a matter of duty and tort, not to be negligent or to commit some kind of intentional tort. Based on that dichotomy between the fiduciary duties of the guardians, guardian ad litem, and the state employees who are simply servants of the state of Kansas, which has a financial dog in this fight, as well as a management dog in this fight, I think that the guardians stand much, much higher. And also the guardians are subject, unlike the state employees, they're subject to continuing strict
Mr.
scrutiny.
Kerwick? Oh,
Yes, Your Honor, I'm sorry.
yeah, no, you're fine. How do we review that? I mean, if she did have no regard for the guardians or the GALs, and they were fiduciaries versus perhaps witnesses beholden to Parsons, how is that something that we can even touch with a 10-foot pole?
I think it's pretty close to an error of law. I'm not positive of that, and I haven't researched it, Your Honor, but it's certainly a matter of reaching findings that were contrary to the evidence, and also ignoring uncontradicted evidence. And I think also, basically in this case, where if you read that opinion, it is certainly written as an advocacy document, much more so than most district court prose I've had the pleasure of reading. I think there's abuse of discretion in here. One reason I mentioned, and it's in my notes a little bit further down, that I thought the district court had abused their discretion. I've done a lot of work in fiduciary representative kind of situations in the context of settling and obtaining court approval for tort settlements involving injuries to minors or incapacitated people. In my experience of over almost 40 years, competent, fair-minded district judges will usually either question the people who are the ultimate beneficiaries who are having a case settled by their parents or their guardian or a conservator or whatever. Judge Moore basically refused to try and question or make any detailed observation to Catherine Rawl. And that's a pretty aggressive statement. And ordinarily, I wouldn't blame you if you criticized me for it. But the way to tell it is read through the opinion and find where, if any place, Judge Moore gives her observation on what this person in her court for a week appeared to be the situation, whether she agreed with the guardian ad litem or me. I think I may have testified to this point, where it's virtually impossible to have rational, sentient kind of conversations with Catherine.
Let me ask you another question on your first point, the role of the ADA and the purposes and policies behind it, and whether it's, giving discretion to state bureaucrats, I just wrote down what you said, versus protecting the rights of the disabled. What exactly are you asking us to do there?
We would, at this point, Your Honor, I think like to have the injunction entered. Injunctions, even if permanent, are always subject to further review. If the state could come in and show some change in circumstances or whatever.
No, but I'm saying, you were talking about the purpose and policy behind the ADA. How do we get to the purpose and policy when the ADA has statutes and regulations, and we can look to the plain language of that? Why would we go beyond the statutory language to the purpose and policy?
Well, the statutory language is one thing, but I think the language in Olmstead requiring is the middle part of the test for a placement is the agreement of the disabled person, or in this case, their representatives, that needs to be honored, even if you can argue that is perhaps some kind of dicta. In my experience as the U.S. Supreme Court tends to mean what it says and say what it means. And it's not for a state district court to be throwing that out and disregarding it. I think the state needs to prove that there is some kind of consent or that there's an arbitrariness or impropriety in the acts of the guardians. And I think, and I'm now talking off the cuff on this, but I think perhaps the place for attack on that is the court that established that guardianship, the probate court of Labette County.
Okay, and then you feel free to go on to your third point. I just wanted to go back to the second and first point to understand what you were arguing.
My third one really was...
Mr. Kerwick, real quickly, before you talk about your third point, because I want you to be able to get to it, but we are, let's just say, out of time. So let me give you 2 minutes and you can make the third point. And then if there are any other questions from the panel, I want to make sure that they can ask those questions. All right.
I really don't have much else, Your Honor. Just the other thing is there's a very important provision at the tail end of the U.S. Constitution in Article 6 called the Supremacy Clause. And I think there's very, very little consideration given to the role of federal law, in this case down in the state court. I think there's disproportionate recourse to Kansas state law that wasn't particularly important. But in any event, to the extent that any Kansas law differs with the Social Security Act or the ADA, it's a no-go. And that in itself is a matter of reversal, as a matter of law. And we'd simply ask that the case be reversed with remanded with instructions that an injunction be entered to preserve the status quo as it was in summer of 2016. And let me just hit one more fact that hasn't been going here, because the state would like to portray themselves as knights on shining armor here. Dr. Ray, the then superintendent of Parsons, sent a letter to the two guardians in, I believe, about June 2016. And it was, in essence, you get in here and pick out some kind of an outside caretaker to go ahead and do this, or we will deliver Catherine Rawl to your doorstep and you can take it over. That is, I think, more indicative of the attitude of the Parsons folks than the rather sugar-coated version that appears throughout this case. Thank you, Your Honor. Do you have any other questions?
Any other questions from the panel?
No, thank you very much.
Thank you both.
Thank you. Thank you to all the council today for your arguments, and again for making these arguments in this setting, for sure. The court will take the matter under advisement, and we will issue our decision as soon as we're able. And that concludes today's arguments. Thank you.
Thank you, Your Honor.